It is exciting for me to be with you today to talk about this very difficult task, among the most difficult tasks attorneys can have. Everybody gets bothered. Well, there was a little discussion at the end of the last presentation about the different reactions that people have to violent acts compared to sexual assault. How we, in video games, it doesn't seem to bother anybody a whole lot that the avatars are going around killing each other with the blood, pouring out onto the sidewalk, whereas we are quite concerned as a society that there could be rapes carried out by avatars on other avatars. And that reminded me of my topic for you today, because it's never nice to be standing in front of a court or dealing with a prosecutor or opposing counsel, negotiating with opposing counsel when you're representing someone who's done something bad. But if that something bad is sexual, then the challenges are special. Then there's a visceral reaction to sexual misconduct, a disgust at sexual misconduct, which makes the advocate's job a very difficult job. The kinds of cases I have in mind are certainly criminal cases and family law cases, but really any kind of case. The power of sexual misconduct is so great. The power to draw our attention is so great. To turn our stomachs is so great that people will inject it wherever they can. If you don't have the relevant facts on your side, well, thank goodness you got some irrelevant ones about sexual misconduct. Let's play on those. So I'm going to talk about particular advocacy situations and give particular advice, but first I want to talk about the foundation for effective advocacy for someone who's committed sexual misconduct. That foundation is your attitude toward your client. Regardless of what they've done, and regardless of who you're talking to, the foundation of your advocacy has to be your attitude toward your client. Let's talk about the question. When you let people know that from time to time you end up representing people who've engaged in sexual misconduct, and when I say people, I mean any kind of people, is there a question that you often hear from those people? Is there a question at a PTA meeting or a party with your neighbors or a gathering for Christmas with your extended relatives that those people ask you? Somebody might ask you when they find out that you represent people who engage in sexual misconduct. Anybody can? How could you defend them? Absolutely. How can you defend those people? Right. How can you defend those people? How can you do that? Well, what is the implication of that question? It is that they're really people. They're demons. That's what they are. To represent them well, we have to have an attitude that they are not demons. They are ordinary folks. They are flesh and blood human beings. Like every human being, each of them is a bundle of virtues and vices. And the way I often put it about my clients is, when I'm talking about my clients is, I'm prone to eat too many desserts, and I'm unfortunately, the people I represent, unfortunately, are struck with vices that are more antisocial and more illegal. But we're all a bundle of virtues and vices, and we're all worthy of respect. We're all worthy of love. If you believe in God, then you might want to say, as I often do, my children of God. I'm taking care of God's children when I take care of them. They're all worthy of not just our respect, but our love. We have to really care about them. At our firm, this is a core firm that we care about our clients, we respect our clients, and we show them compassion. Now, I'm speaking often of, in our firm, a lot of the people who come to us, they have come to us primarily because they've misconduct. It's not as though they have a family law case and the opposing injected this perhaps extraneous sexual misconduct aspect into it. It's often at the core of the reason they've come to see us. And they are profoundly in need of compassion. They are commonly rejected by just about everyone in their lives. They feel a great sense of shame. And showing them compassion is one of the fundamental services we provide. With that goes, of course, respect. The C being if you get to know them a little bit. So we ask people about things that are not a part of their case. We ask them about their lives and their interests and the things they get excited about in a good way. We want to humanize them in our own minds as before we set about humanizing them in the minds of the person to whom we will advocate for them. Now, in what situations are called to advocate for sexual misconduct? I'd like to hear situations you find yourselves in which you have to advocate who's committed sexual misconduct. Yes, ma'am?
I do relief from registration for juveniles.
Relief from sex offender registration. So you're going Superior Court, juvenile, and you're advocating to the judge there. Are you also advocating sometimes to the prosecutor?
I wouldn't say advocating to them.
You're never able to before.
Sometimes they defer, which is as good as I can hope for, I guess. But yeah, I advocate to the judge, to the prosecutor, to
Okay.
family members if they're presenting a barrier.
Have you? Yes, sir.
Parenting plan for a client who's had the example I'm thinking of, he was accused as a juvenile and there's a record of it. And it wasn't a problem until they divorced his wife. So now it's an issue.
His wife knew about it all along, and it wasn't a problem until they were planning not to go on as husband and wife.
And there was a parenting plan of visitation.
Yeah. Okay. So are you trying to negotiate an outcome in that?
No, but I'm worried about it because I don't think it's what he did as a juvenile is admissible in this situation, but I'm not sure because I've come across it before in a trial. I was arguing against somebody who had committed an offense as a juvenile, and I got away with it, but I didn't get the outcome that I wanted.
Yeah. So we sometimes find ourselves arguing with the court, or advocating to the court, and sometimes advocating to opposing counsel, sometimes advocating to a mediator in a mediation. There are a variety of situations, and I think the different situations call for different forms of advocacy. But in every situation, you want to tell a story. And I'll go a little further and say, in every story, in every situation, when you tell that story, it's a story that has 3 chapters in it. Chapter 1, the fall. The client's fall from grace. The client's fall from sexual morality. Chapter 2.
Whom shall I call for you?
I'm busy, so don't have them call me. So the client's anguish. The client's anguish is chapter 2. And chapter 3 We have a happy ending. It's the client's triumph. So let's take a look at those chapters individually. The fall chapter, the chapter of how your client fell from sexual immorality, this is one that will probably have been told, not the way you would tell it, but will have probably have been told by your adversary, or if your adversary hasn't yet had a chance to say his or her piece, he or she will. So this is probably going to be the shortest of your 3 chapters. Probably needs to be the shortest of your 3 chapters. But one thing that I suggested include is any handicaps your client had that set the stage for his or her sexual misconduct. These handicaps can make your client more sympathetic and make your job as an advocate, make the fall more understandable, less blameworthy, and can make your job as an advocate easier. For example, people who engage in sexual misconduct many times are socially isolated. And so if your client is socially isolated, maybe due to, there are a lot of reasons a person could be a social misfit. I don't need to start listing them. But if your client suffers from any of them and has been socially isolated, that's worth pointing out as part of the fall story. Now, the anguish chapter has 3 purposes. This is the story, of your client's misery, how badly your client feels about what he or she has done. First, when we show that the client felt great guilt, we're humanizing the client. If the client were a demon, the client wouldn't feel great guilt. The client would say, "Got away with another one. Let's go on and let's go on to my next sexual misconduct." But the great guilt of the client enhances the humanity and makes the client more attractive and less in need of punishment. Another reason the client is less in need of punishment is that the client has already suffered. The anguish that's another thing that the anguish is telling the target of your advocacy. Hey, judge, my client has suffered a lot, and so you don't need to make him or her suffer a whole lot more. Of course, that's the implicit statement of the anguish story. And the third ingredient, the third purpose, is that the memory of the anguish will motivate the client. He won't do it again, she won't do it again because it hurts so much from having done it this time. Then we have the triumph chapter. Now, the triumph chapter, when the client first becomes your client, this one you need to be thinking about right from the start, because in the fall and the anguish, you're probably going to be talking about things that have happened mostly before the client came to you. But if you're going to need certain factual ingredients, certain facts to put in your triumph chapter, and if when the client walks in the door those facts don't yet exist, well, hey, there's time. Get the client on the road to make some of those facts. We want, for example, to be able to say that the client has made himself or herself accountable, has held himself or herself to account to somebody. It could be, for example, a public accounting. That can have particular power. I'm thinking of a client at our firm who not only went into a sexaholics type program and participated, but gave talks to the other people in the program about the perils of using the internet when there's so much child pornography on it. That was his misconduct, and he was willing to expose himself within the sexaholics community as a person who had that problem. And maybe if you have a client who's willing to expose themselves even beyond that, that's going to have more power. So that's a form of accountability that is particularly powerful and an ingredient in your triumph chapter. The client has reformed. That needs to be a part. This is, of course, where James Olson and the community of sex offender treatment providers come in. Sometimes the client will come to us and expect that they will not need to get any treatment until the court orders them to get treatment. Well, that's not going to give us much to work with when we're standing in front of the sentencing judge and we want to say the client has reformed. We want to show that the client was eager to get into treatment and did it right away. The client has made amends to the victim. This can be through paying restitution. It's something that needs to be done delicately because the victim of sexual misconduct may not really want to have anything to do with the client after the misconduct. And we have, certainly in our office, we have seen people who are so self-focused that when they're thinking about making amends to the victim, they're really thinking about making themselves feel better. They need our help, the help of a sex offender treatment provider, in looking at it from the perspective of the victim. What's gonna feel like some sort of reparation, some sort of amendment, some sort of welcome reaching out to the victim. They often need help to know how to do that. And the client, the Triumph chapter also needs to show that the client has done something to protect himself or herself from risky situations, to ensure that he or she won't regress into that bad behavior that they've engaged in once. So it might mean not using the internet except under supervision. It might mean being, there are a lot of things that courts do later that clients can do proactively ahead of the courts. Limiting putting themselves under supervision when they're around children, for example, or removing themselves from environments in which they're going to be around children, if we're talking about sexual misconduct with children. So those are the fundamental pieces in the story that an advocate needs to tell. I think regardless of who the advocacy is being delivered to. I want to turn in a moment to think about the different people in particular, but just before doing that, let's think about some risky arguments. Some of the things we might want to argue can backfire. And there are two categories of risky argument in particular that I want to turn our attention to. One is an argument that recognizes how another person's actions contributed to the misconduct. And the second is an argument that puts the misconduct in perspective. Can anybody think of any words that opposing counsel might use to paraphrase those types of arguments? Recognizing how another person's actions contributed to the misconduct. What do some people call that? Blaming the victim. Bingo. Putting the misconduct in perspective. Minimizing. Defensiveness. Right. So, I wish I could say, I've got the solution, I've got the practice tip that will guarantee that when you make an argument like that, nobody will ever say, oh, you're blaming the victim. Nobody will ever say, that's defensiveness, that's minimization. I can't do that. But what I think I can do is give you some help in how and where you can make these risky arguments so that, you're still going to hear those words, but they're not going to have as much power as they otherwise would. So, we have to consider the setting in which the advocacy is being enacted, which is being performed. In a meeting with opposing counsel, in which the conversation, it's oral communication, I think that is probably the safest setting that we're likely to encounter for using risky arguments. It's more likely that opposing counsel will see the merit, and you can't be very effectively, you can be quoted, but it's not going to have a lot of power if it's just what opposing counsel says you said. So that's fairly low risk, a fairly low risk environment for a high risk argument. A written submission that will be available to the public, that's at the other end of the spectrum. So a brief you're going to file in court, that can be thrown back at you at any time. It can be passed around to people who might be very offended and have the power to make your life difficult, your client's life difficult because of that argument you made. Even a letter that you write to opposing counsel can be copied and sent on to the client or submitted to the court. In a mediation situation, in all the mediations I've been to, and I confess I haven't been to any in family law, so if the customs are different there, I'm not aware of it. In mediation sessions I've been to, the parties each have the opportunity to send a letter to the mediator in anticipation of the mediation, and the parties can send a copy of that letter to opposing counsel or not, as they wish. My thought is you could send two. If you've got a high-risk argument you want to make to the mediator, that goes in the letter that you're not sending to opposing counsel, and the opposing counsel gets only the letter that doesn't contain that argument. In open court, I think you have to be especially sensitive. If you make a high-risk argument, remember, our judges are elected. They do not want to seem to be buying arguments that will put them in the soup that judge in Santa Clara County, California is in right now. The one who sentenced, this was, he got in the soup many months ago, maybe it's now been years, I'm not sure, sentenced the Stanford athlete in a rape case to, I believe, 6 months. He's undergoing recall right now, he's facing recall. Our judges don't want to be in a situation like that. So if you make a high-risk argument in open court, the judge may be a little more reluctant to rule for you because it looks like the judge is buying your high-risk argument. The judge doesn't want to see the newspaper article whose first paragraph is the terrible thing the judge did, and whose second paragraph is the argument that you made that the judge apparently bought that caused the judge to do that terrible thing. Let's look at some particular high-risk arguments. Oops, that's not where we want to go yet. Oh yeah, I don't have a slide for this one. So I'll talk louder. One of the things that I mentioned earlier when I was introducing MA is in our office now we're getting a lot of sexual assault disciplinary proceedings on campus these days, the so-called Title IX cases. And you don't have to be a lawyer to know that there's a great emphasis in our society now on consent, the importance of getting a consent, the right of a participant in an encounter between two people to stop the proceedings at any point. And certainly that's as it should be. Either party to sexual activity should be able to say, oh, change my mind at any point and have that respected. But, human nature, human sexuality, they make this difficult. Turning back when one is fully aroused and expecting sexual satisfaction, this is not a simple thing to do. How can you make that argument without offending people? Well, often the best way to make an argument that you're reluctant to state as an argument is to just state the facts in great detail and to let the logic emanate from the facts. That can be a little dangerous, though, in the area of sexual misconduct, because a very detailed recitation of the facts can have a cinematic quality. And we don't really want people seeing that movie. You know, that's going to have a visceral reaction. The more cinematic, the more visceral, that's a problem. So I think the way to do it is to state some of the facts, state the key facts, just don't go into too much detail. Keep it a bit abstract. And you don't even have to say that the facts reduce culpability, because it should be obvious that they do from your statement. So let me make what I've just said a little less abstract with an example. Here's an argument you might make. No question about it. It was Mr. Smith's duty not to proceed to intercourse if Miss Jones withdrew her consent. It didn't matter that they were in bed together. It didn't matter that they were completely undressed. It didn't matter that he was fully aroused through mutual foreplay when she withdrew her consent. It was his duty to stop the instant she withdrew consent. Now, anybody listening to that argument will have heard you say it didn't matter 3 times, but will have understood it did matter. Another of the high-risk arguments is to put sexual misconduct in perspective. How can we do that without, we can't eliminate the risk that we're going to be called minimizers. How can we do that by minimizing the damage done when we're called minimizers? First, one denounces all of the forms of this, all of the varieties of this particular sexual misconduct that has been committed. Then one observes that some varieties of this particular kind of sexual misconduct are worse than others. Then note the bad features of some of the acts that fall under this heading that your case does not have. Again, an example. Your Honor, every sexual touching of a child is a grave offense. Some sexual touchings of children are of course worse than others. Any decent system of justice takes into account the particular features of each case. Joe defendant, Your Honor, did not penetrate. He did not do this multiple times. He did not use force. He did not threaten the child that if she told, there would be repercussions. Those are the facts of this case, Your Honor. Okay, so much for risky arguments. I think it's rather safe in the modern world to point as a part of your argument to the sexualization of American life. And the older your audience, the better. I was born in 1950. I guess for those of you who didn't live through the 1950s, you know it through fable. And the fables are pretty much matched the way I remember it. It was a really different time. And people who come from back in the middle of the century, I think, are very ready to accept the idea that there's a whole lot of temptation out there, that a whole lot of sexual temptation out there that nobody had to cope with in earlier times. So I don't see that as a high-risk argument. I think that's a safe argument, as long as you don't, of course, make it sound like an excuse. Now let's arm some other advocates. Let's arm some other advocates who can go to bat for your client. In the criminal sentencing realm, a lot of the help we get comes through the mailbox. We have a letter that we give to our clients, and now you have that letter among your materials for this program, which tells the client's family and friends, supporters of any kind, could be an employer, fellow student, how they can help. And we tell them they could come to the sentencing hearing and speak, or they could write a letter. And of course, we have far more of them who want to write letters than who want to come and speak. Couple of points about these letters. It's important that they go to the attorney first. We say write them in, the Honorable Sally Judge in care of A. May Sutton, the Marshall Defense Firm, etc. Because we often see letters that we don't want going to the judge. It's not unusual for the client to have let his, I won't say to have misled his family and friends, but to have let them mislead themselves. They want to think, well, of course, he didn't really do this. He's not the kind of person who would do this. It's got to be a hatchet job by the prosecution or his ex-wife, and the clients are sometimes not aggressive in correcting that impression. So we will want to make sure that this letter is not going to be a negative at sentencing rather than a positive. And so we try to get these letters. We set a deadline early enough that we can revise them, send them back, and say, can we submit it this way? A lot of people in the modern era don't think, the email era, it completely eludes them that there could be any value in signing a letter and putting a date on it. We remind people that the judges give them more credibility if they're signed. And now we actually learned something through one of our cases that it's a little bit embarrassing how it took me almost 2 decades to learn this. We used to tell people, who are writing these letters, it used to be in the form letter that we've given the updated version of to you, that they should stay away from the sexual misconduct entirely. Talk about the wonderful thing he did on the Boy Scout camping trip, or as your neighbor, or as your employee, but just leave the offense conduct aside. Well, in one of A. May's cases, the judge said to her at sentencing, boy, these are really impressive letters, and they tell me an awful lot about Mr. Client here. It just seems peculiar that none of them says anything about the offense conduct. So, I'm slow, but I can learn. So we now encourage people to talk about the client's remorse and his attitude about the offense conduct, if they can do that. Of course, they can't do it if the client hasn't talked to them about the offense at all. But if he has, then that's a great thing to have in the letter, to demonstrate the client's remorse, to prove. And that's not just the client who says he's remorseful. Here's a letter from somebody who's heard him express his remorse. When the client gets to court, I'm thinking again about a criminal sentencing situation. It can be, I talked a few minutes ago about making amends to the victim and the need to be sensitive to the victim's perspective in doing that. I think, the criminal sentencing hearing may be the only time that the client gets to communicate with the victim from the time that the victim reported the offense for a year or two to come, because of course there's been a no contact order as a part of the legal proceedings. There's going to be a no contact order as a part of the sentence, and there may be some provision in there to permit eventual contact when both sides' therapists approve of it, but that's going to take a while. So James, you can tell me at the end here if you think I'm doing a bad, but I tell clients, usually when the client himself asks about it, if the victim comes to the sentencing hearing, that's the only time they're going to be in the same room during a span of years probably. If the victim comes to the sentencing and the client wants to turn and say, Sally, I am so sorry, that's okay. If it goes longer than that, then I know the victim's going to become uncomfortable. They don't like to be, and I've seen that happen in court where the client goes on, and the client, perhaps through her representative, the victim, perhaps through her representative, tells the judge, asks the judge to tell the defendant to turn around and talk about something else. But I have seen that done, and I think it can be effective. What do I mean when I say effective? I don't think it makes a bad impression on the judge, and I think it can make a good impression on the victim. Okay, here's one that I wrestled with as I was preparing to speak to you today. This question. Suppose, let's get out of the criminal sentencing context for a sex offense. Let's imagine we're in some other kind of case where the sexual misconduct there's at least a good argument that it is not relevant at all. Can you both argue that it's irrelevant and answer it? Well, hey, if it's irrelevant, why are you, those are somewhat inconsistent arguments. I think you can, and I think you can make them consistent. The overarching theme of those two arguments is opposing counsel is playing dirty tricks. You start by addressing the allegations in brief to show, and the theme of your addressing the allegations is to show that they've been misstated. It's the sexual misconduct is not as the other side says it was. The other side is playing dirty here. And then, but we shouldn't even be talking about this, Your Honor, because it's irrelevant. And the only reason we are talking about it is because the other side is playing dirty. So if the other side playing dirty is your theme, I think you can both address the allegations of sexual misconduct and Gesundheit and say they are irrelevant. Show me that sign again, please, Polly. Thank you. Okay. Well, I have. So let's say what materials we have, and then I see I have made a little faster progress through my presentation than I meant to, so we're going to have some time for questions. You've got the form letter that we pass out to our clients for them to give to their friends and family if they're coming up for a criminal sentencing. You've got an article on showing compassion for clients, and you've got a brief that our firm submitted on behalf of a client several years ago, and I enclosed that brief because it illustrates the three-chapter story. It's got, then when you look at the brief, you won't find section 2, section 1, fall, section 2, anguish, section 3, triumph. But I think if you read it, you'll find all three of those chapters in there. I confess, I'll say it before you do after reading the brief, we had a lot to work with there. This was a guy who, he was a master reformer. He was a model reformer. And of course you can't write a brief quite like that one if you have only a B plus reformer. But a B plus story is better than none, better than just disorganized advocacy. All right, that's all I had prepared. If you have any questions, I would love to hear them. Yes, sir.
You had mentioned that something that sometimes advise clients, or you talked about having them apologize from the lectern to the victim, however briefly. Have you ever run into any problems or saber rattling from the prosecution that this might run afoul of a no contact order?
I haven't. I'll confess, it's not as though I've seen this done 50 times, so I suppose if I had, I would see something like that. But I think it's implicit in all no contact orders that when they're both properly in court, that doesn't count. Yes, ma'am.
So, advocating for clients at arraignments.
Mm-hmm.
So a lot of my clients obviously want to be able to have contact with their nephews, have contact with their biological children, other minors. So we've been having a debate recently about whether to get letters that say, hey, this person feels safe around, I feel safe with Joe charged with child molestation around my child. How do you feel about putting that kind of information in a letter and having that come out at arraignment? Because there's that double-edged sword, right? They might get to visit their child, and then later on, when there's a treasure trove of child pornography on the computer, it's a different story. So I'm just wondering how you feel about advocating for those kind of things.
Well, I always want anyone who's going to be living with or close to, in any sort of vaguely supervisory role with my client, I always want that person at arraignment to be concerned that this might be true. And this is a speech, a conversation that I very often have to have with, let's say, the spouse before arraignment happens, because she thinks the best thing she can do for her husband is to say, I know this man so well, and I know this is absolutely untrue, couldn't possibly be true, which of course says to the judge, she's not going to be paying attention to whether her husband is misbehaving with their daughter. We can't count on her, to do any problems for supervision. And the same principle would apply, I think, if we're talking about, brother or sister with children. So I think any presentation like that would have to be phrased in terms of, I've known Joe defendant a long time, and boy, this is so inconsistent with everything I know about him, but I recognize these are serious charges, and everybody has to take seriously the possibility that it's true. Certainly I do, Your Honor. I take this seriously. Then if you want to have the best argument for access to children, I think you probably need to bring in a professional from the sex offender treatment community. Ideally, I've seen this done. I was involved in a case where the spouse's attorney brought in someone to interview the child who was 12 or 13 to make sure that she was able to speak for herself, that if the defendant did anything he shouldn't do, she would know she should tell mom, she should tell the police, whatever. She should ring up the alarm right away. She was going to be a good self-advocate. And I think that can make it easier for the judge too. Of course, that's not going to work if the child's 4. So have I gotten to what you had in mind there?
That's exactly what I was
Okay.
thinking about. How do you deal with it when you don't know what all the facts are yet?
Yeah. Okay. Yeah, the fundamental point there is people are making a big mistake. The supporters of the client are making a big mistake if they think that they do the client a favor by telling everybody, couldn't possibly be true. I know this guy and I know it's absolutely impossible. That's not what they need to be saying at the very beginning. Yes, Christina.
So in the same vein, as you get to the end of the case, you're at sentencing, you've elicited letters of support on behalf of the defendant. You mentioned that there have been letters where the supporter didn't mention anything about the existence of the charge.
Right.
Have you ever knowingly submitted a letter written by somebody who doesn't know what the defendant was convicted of?
Have you ever knowingly done that? I don't think.
Grandma was never told what Joe really was looking at?
I don't think we've knowingly done it, but we might have unknowingly done it. We don't ask people to make their opening paragraph. I write because I know you're about to sentence my grandson for rape of a child in the first degree. So it's possible.
Isn't it leave open the possibility in the judge's mind that this letter of support is written by somebody who in fact is ignorant about what's going on?
It does. I mean, but we emphasize the need. Don't just say he's really a nice guy, I love him a lot, cut him a break. Talk about, give us details, give us facts, tell us a story about something noble or at least nice that he has done at some point. So if that's told by someone who doesn't know about this other side of his life, well, it still can be a true presentation of this virtuous side that we want the judge to know about. So I don't see it as a big problem. All right. Thank you all very much.